Case People versus Thomas.
All right. Welcome back to another How Did We Get Here? Courtroom breakdown. Because this case starts the way every chaotic courtroom clip starts. The music hits, the tension rises, and somebody is already prepared to argue with reality itself. This is People versus Thomas Styron, and from the jump, we're dealing with one of the most dangerous combinations in court. A defendant who thinks he knows the law, but actually only knows internet law. We've got Judge Simpson, male, running the courtroom. We've got the public defender ready to step in, and we've got Mr. Styron, who immediately signals he wants to represent himself. Now listen, in America, you can represent yourself. It's a constitutional right. But it's also like saying, I'm going to do my own surgery because I watched a YouTube tutorial. You can, but you probably shouldn't. And this is where it gets intense. The judge is trying to establish control because if the defendant turns the courtroom into a circus, the case can drag, evidence can get messed up, and the defendant can literally sabotage himself. Here's the twist you need to pay attention to. This isn't just a minor misunderstanding. This man is charged with multiple crimes, and the state is hinting at even more charges coming. So the stakes are huge.
Styron. Here we go.
Assistant Public Defender Otella on behalf of Mr. Styron, who stands to my left. Well, let's talk to the judge about that, right?
We've been through this. Seems to be some confusion.
What's the confusion?
I've stated multiple times on the record that I wish to represent myself.
Well, I thought we got rid of that issue the last.
Yeah, I thought so too. I spoke to this gentleman right here and expressed my wish to represent myself as well.
This right here is the first big red flag moment. Not because he wants to represent himself, but because of how he's framing it. When people say, I stated multiple times on the record, that's usually courtroom speak for, I'm already in a power struggle with the court. Judge Simpson is doing what judges are required to do when someone wants to go pro se, represent themselves. The court must make sure the defendant understands what they're doing. Because if the judge just allows it without warnings, and the defendant gets railroaded later, it becomes an appeal issue. Now, this is not the judge being dramatic. This is the judge building a legal safety net. Check, you understand your charges. Check, you understand consequences. Check, you understand procedures. But here's where the tone shifts. The defendant isn't just asking to self-represent. He's challenging the whole framework, like the court is hiding something from him. And when a courtroom becomes me versus the system, it stops being about facts and starts being about ego. And ego is expensive in court. It can cost you bond, it can cost you credibility, and it can absolutely cost you years of your life.
All right. Well, if he doesn't want you, I mean, we'll figure that out in a moment. So, Mr. Styron, we're going to go through this again. What do we want to do in this case? You understand what you're charged with, sir?
So, I understand what the charges are against me, yeah.
Okay, look, you're going to have to give me straightforward answers to my questions because I've got to make sure that you understand certain things. I got to do certain things here.
From my understanding,
You understand, first of all, that if you do indeed direct, you want to smile about it and laugh about it, take him back. We'll call him out later. Take him back. You keep laughing. You laugh one more time, that's 30 days. Go contempt.
Ouch. This is the find out portion of the video. Because Judge Simpson just pulled out the nuclear option, criminal contempt. And that's important for viewers to understand. Contempt is not a timeout. It's not a warning. It's the court saying, you are obstructing these proceedings and I'm punishing you immediately. When a judge says 30 days, that's not a metaphor. That means you're going back to jail for disrespecting the court. And the biggest mistake defendants make is assuming the courtroom is like social media, where you can act reckless, and the worst that happens is a comment section drags you. Number. In court, disrespect has a price tag. Now, do I think it's harsh to hit him with 30 days for laughing? That depends. Because what judges are really reacting to is not the laugh. It's what the laugh represents. Defiance, mockery, refusal to cooperate. Judges tolerate confusion, fear, nervousness. What they don't tolerate is a defendant performing for attention. And let me tell you, this moment changes everything. Once contempt is on the table, now the defendant is walking into every future hearing with a reputation. This is the guy who can't control himself. That affects bond, rulings, everything. Audience question: was the judge too harsh here? Or was that exactly what this defendant needed?
Look it up. You may need an attorney. Your fault. First calls the case of the people versus tyrants. Recall.
You're compelling me to identify as Thomas York Steiner?
And here we go. This is what I call the sovereign citizen adjacent spiral. Because he just started using the language of the legal entity argument. This is a very specific type of courtroom behavior where the defendant tries to claim, the person in court isn't me. That name is a corporate trust entity. Let me break it down clearly. Courts do not accept this, ever. Your name on the case is your legal identity for criminal prosecution. You don't get to dodge felony charges by saying, that's not me, that's my legal entity. That might sound clever on a forum, but in real court, it gets you one thing: contempt, sanctions, and a very irritated judge. Also notice, the court clerk states on the record that the defendant was already found in contempt previously and sentenced to 30 days. That tells us this isn't his first time turning the courtroom into a debate club. He starts talking about social security numbers, trusts, fraud, and at this point, he is no longer addressing the allegations. He's trying to put the court itself on trial. And here's what's scary. Defendants who do this often think they're winning, when in reality, they're digging a legal grave with a golden shovel.
The legal entity on this case?
I believe that you are. Do you understand the nature of the charge, sir?
I don't understand how the name you have on the case and who I am, it's two different people.
Defendant, as he was leaving the courtroom the last time, the court did find the defendant in contempt, sentenced him to 30 days. Defendant will serve that sentence. The court will sign the judgment of sentence regarding the contempt.
I don't understand how that's possible. Like I said, I'm
So
a
first of all, watch your
beneficiary. You're treating me as if I'm the trustee, or I don't want to partake in any trust fraud or anything like that. Is this a QVA trust matter involved in this? Is my social security number attached to this at all? Go figure.
Mr. Styron, or whoever you wish to be addressed as, I'd suggest that you watch yourself because there's going to be more time coming. You keep it up.
This is Judge Simpson basically saying, I'm done entertaining nonsense. And look at how the judge words it, Mr. Styron or whoever you wish to be addressed as. That's the judge giving a tiny courtesy, while still enforcing courtroom authority. This part matters because the judge is setting boundaries. You will conduct yourself appropriately. You will not disrespect the institution. You will not talk to me in that fashion. And the defendant responds, I'm not the one being unethical. That's a massive escalation, because accusing the court of unethical conduct is like walking into a police station and saying, you're all criminals. You may feel emotional, but that accusation has no proof, and it kills your credibility. The judge says, very good, you'll serve the 30 days. That's the final gavel drop. From that point on, and the defendant is not in a negotiation, he's in a consequence. And if you're thinking, why doesn't the judge just ignore it? Because allowing a courtroom to be disrespected erodes the legitimacy of the entire process. The judge isn't just managing one man. He's managing an entire system.
You will learn how to conduct yourself appropriately in these proceedings in this courtroom and before me. You will not in any manner whatsoever
You're trying to compel me to be somebody I'm not.
Or this institution.
You have no evidence
It will not
to prove
happen.
that I'm who you say I am.
You will not talk to me in that fashion.
In what fashion? I'm not the one being unethical.
Very good. You'll serve the 30 days. We'll see. You can go right there. We're having it. Court does call the case of People's State of Michigan versus Thomas Styron II.
Good afternoon, Your Honor. I'm Philippines on behalf of the club.
Sir, state your name, please.
I'm George Styron, second.
All right. This date and time set for preliminary examination. Mr. Styron, you are here representing yourself. I would indicate to you that there are 3 charges on the complaint in this case. The first charge is that of fleeing a police officer.
All right, now we're in serious territory. This is where the judge lays out the actual legal stakes in plain English. And this part is crucial for viewers because now we understand what this man is truly facing. Count 1, fleeing a police officer, 3rd degree, felony, up to 5 years and fines/costs. Count 2, assaulting/resisting/obstructing a police officer, felony, up to 2 years and fines/costs. Count 3, driving on a suspended/denied/revoked license, misdemeanor, up to 93 days. And then the judge explains the purpose of today, preliminary examination. That's not a trial. That's where prosecutors must show probable cause that a felony was committed and that the defendant likely did it. If they succeed, he gets bound over to circuit court for trial. And the judge gives him another warning. If you represent yourself, you'll be held to the same standard as a lawyer, meaning you don't get special treatment because you're not trained. You don't get to violate procedure because you're confused. That's why self-representation is so dangerous. The law doesn't slow down just because you refuse counsel.
Under the Motor Vehicle Code, in the 3rd degree, that is a felony punishable by up to 5 years and a $1,000 fine plus court costs. Count 2 on the complaint alleges assaulting, resisting, and obstructing a police officer. That is a felony punishable or a high court misdemeanor punishable by up to 2 years incarceration and or a $2,000 fine plus court costs. Count 3 is a charge of driving while license suspended, denied, and or revoked. That is a misdemeanor punishable by up to 93 days in jail and or a $500 fine plus court costs. The subject matter of this preliminary examination is for the people to establish by probable cause that the felonies have been committed. If the people do establish that, then you would be what's called bound over to stand trial in the circuit court. You are here appearing without counsel. I would advise you that if you wish to represent or be represented by counsel, you can let the court know, and the court would make sure that counsel would be available to you in this proceeding. I would also indicate that if you are desirous of continuing to represent yourself, you certainly have an absolute and constitutional right to do so. You will be held to the same standard that attorneys are held to regarding the court rules, regarding the presentation of evidence, and anything else along those lines, as well as questioning of the witnesses. Do you understand all of that, sir?
I understand everything.
Pardon?
I understand everything.
Okay. And, sir, do you still wish to proceed unrepresented?
Yeah.
Very good. Do you have any questions before we begin the preliminary examination?
I haven't had a chance to look at the body cam and the evidence. I just got a kite back yesterday telling me I could ask the new staff to be able to view this. I've got maybe 45 minutes or an hour's worth of time in it so far. I'm able to get through the first video.
45 minutes, an hour into what?
I think there's 16 videos on the thumb drive. And I think Officer Hooks is an hour and 15 minutes long in itself. So what I'm saying is I've had insufficient time and evidence to even.
Now this is where it gets interesting, because for the first time, the defendant makes a point that is actually valid. He says he hasn't had enough time to review the body cam footage in discovery. And in fairness, discovery review is not optional. It's essential for defense, especially if you're representing yourself. If there are 15 to 16 videos and one body cam alone is over an hour long, that's a lot, especially in jail, where access is limited and unpredictable. That's not excuse making, that's reality. And notice the judge's response. The judge says the prosecutor won't even be using the body cam today and will proceed just with a witness testimony. That's strategic. The state is trying to bind him over without needing video evidence in this hearing. But the defense, even self-represented, can argue, I need access to evidence to cross-examine properly. Even the public defender highlights the risk. What if the body cam contains something that helps the defendant? That's exactly why discovery exists. And then the bomb drops. The prosecution admits they plan to add felony assault and felony firearm counts. Mandatory 2 years. That's huge. This case just went from serious to potentially life-altering.
Review it, be able to articulate.
Excuse.
Your Honor, I understand that the APA that was present before me had intended to admit at some of the body camera. I will not be using any of it today. I'll be proceeding with just Sergeant Howe's testimony.
I guess and I understand that misuse, and I guess the only question would be if whether or not something contained on the body cam might lead to evidence that the defendant either would want to present or lead to evidence that the defendant may wish to question the deputy on. And I'm going to have no way of knowing that.
I appreciate that, Your Honor, especially because my office previously put on the record, and I'll reiterate today, we do plan on adding additional charges, a count of felonious assault, which assault with a dangerous weapon against the sergeant, and 2 counts of felony firearm, which are mandatory 2 years in prison.
That right there is a courtroom jump scare, because the prosecutor just quietly slid in what might be the most important line of this entire hearing. Additional charges are coming, including felonious assault and 2 felony firearm counts. Let's translate what that means in normal human language. The defendant might be facing charges that come with mandatory prison time. No, judge might be lenient. No, maybe probation. No, good behavior helps. A felony firearm charge in Michigan is notorious because it often adds mandatory consecutive time. That's not a slap on the wrist. That's a guaranteed prison sentence if convicted. And notice what makes this especially dangerous. The defendant is still trying to represent himself while the legal terrain is getting worse by the minute. This is like choosing to play chess, while the other side keeps adding pieces to the board. The prosecutor even says they're open to adjourning. That's a strategic move too. They don't want future claims of unfairness. If the defendant later argues he lacked discovery time, that could become an issue. So the prosecutor preemptively looks reasonable.
And so, Your Honor, I don't have a problem if we need to adjourn this room to have more time with the video.
Okay. And under those circumstances, and I forgot, I think you had mentioned that before, that with that. Okay. So, Mr. Styron, you're requesting an adjournment of the proceedings so you can get through that. Is that okay? How far, and I guess that was unclear, you have access to the body cam?
Yes, I do. It's in my property.
Okay. But then you were talking about, you got through some of it?
The first video, and I believe it's a YouTube, not YouTube, but a Facebook video of a bystander.
Say that again.
Facebook video that somebody took.
Okay.
And part of his body, maybe 20 minutes, half hour's worth.
When you're saying his, you're talking about.
Officer Hooks, yes.
Okay.
I believe his body cam footage is an hour and 15 minutes in its totality. So I've barely been able to scratch the surface of that.
Okay, let me ask you. Go ahead. Were you going to say something else on that?
And like I said, I believe there's 15 or 16 videos in there total. Maybe more, and that's just what I was able to see.
Okay, so let me ask you this. How are you arranging to view that video?
This section may seem boring at first, like paperwork and scheduling, but it's actually one of the most revealing parts of the entire transcript, because it shows the brutal difference between rights on paper and rights in real life. Yes, defendants have the right to review evidence, but when you're incarcerated, you don't just open a laptop and click play. You need staff, time slots, supervision, equipment, and jail cooperation. And here the defendant is basically saying, I finally figured out the correct process. Judge Simpson handles this better than most judges, honestly. Instead of dismissing it, he asks practical questions. How are you viewing it? Who arranged it? How long might it take? And the defendant gives a detailed explanation. He contacted correctional services, he spoke with Sergeant Flint, so he learned noon staff can arrange it. This matters because a judge is always balancing two things: court efficiency, cases must move; due process, the defendant must be prepared. And if the defendant is unprepared because the jail blocked access, that becomes a legal fairness issue.
So originally I was kiting everybody I could. I was correctional services, this sergeant, that sergeant. Finally, while down in correctional services, I was able to speak with Sergeant Flint.
Okay.
And he was able to arrange this first meeting. And like I said, I got a kite back from him yesterday telling me just to bother the noon staff and they'll arrange it during the noon shift. So
Gotcha.
prior to yesterday, I was still asking. I guess I was just asking the wrong shift. I was asking later in the day, that's for certain. And I really was never able to get anything else arranged as far as being able to go and view it.
Okay, so you were trying to do it one way, that wasn't happening. You finally got to Flint and he indicated to you that it's the noon staff you're supposed to bother to
Yeah.
try to, okay,
Flint's definitely provided direction in regards to how I can go about getting this.
all right. Okay, so we'll need to then adjourn that. Have you, well, I'm gonna ask it one or two ways. How long do you think it'd take you to get through it? I mean, is it your, and I won't hold you directly to it, but I mean, would you be able to do it in one day if you had access to it? Or is it going to take you a few days, or just your best guesses? Because you know how long the clips are. I don't have any idea by
So,
design.
I only have knowledge of how long his particular video is, Officer Hoops. I don't, the other ones I haven't looked at, viewed, can't remember how big the file is, nothing like that. If I was out in the world, I could probably have this done within a week at my house. I have my own computer and I planned on originally being able to do this. Also, it depends on the jail. They've been so short-staffed. We've been locked down a lot as well. So it depends on what their staffing numbers is during it. When I'm asking or trying to arrange this, there's so many variables. It'd be hard for me to give you a.
No, that's fair. That's fair.
And then also,
But you don't know total. You don't know total time how much there is. You just know that one.
Since May, I've been fighting an illness that just recently the jails addressed. So yeah, there's so many things going on. I've been since May. I've been having stomach issues, bowel issues, and on Friday or Saturday I was urinating blood.
And now, suddenly, the vibe changes. Because we go from legal logistics to something very human. The defendant describes serious medical issues in custody. Now, to be clear, we don't know the full medical truth beyond what he says here. But urinating blood isn't, "I have a cold." That's alarming. And it's a tactic some defendants use. Yes, but it can also be completely legitimate. This is where Judge Simpson has to do something tricky. Acknowledge the seriousness without turning the bond hearing into a medical trial. Courts typically don't release someone just because they feel unwell, unless the jail can't provide adequate care. And you can hear it in the judge's tone. He doesn't mock him. He listens, he responds, but he also keeps the hearing moving because this is still a felony case with public safety concerns. Now, this moment also shows why courtroom behavior matters. If the defendant had stayed calm from the beginning, he'd likely have more credibility here. But after contempt and blowups, every request gets filtered through skepticism. Audience question: when defendants raise health issues in custody, do you see it as a real emergency or a strategy to get out?
Finally, I was able to get some the medical staff to do something with that as far as me urinating the cup and give me some type of antibiotics. But all they can tell me is I have an infection. They just don't know specifically what type of infection. So I'm also dealing with that, and it's making me very lethargic and
Okay, I got you.
energy in that.
What do we,
Progress that as well.
what do we look like on the sixth? Okay, so that we hopefully won't run into this again. You've gotten all of the discovery.
Pardon me.
You got all of the discovery. Like you got the, as far as you know, you got the police report. You have all of that. It's the video. All right. So what I will do is I will adjourn the preliminary examination in this matter. I would go to the 30th, but I think I'll go to August 6th.
This is the court doing what it's supposed to do when fairness is at risk, granting time. The judge adjourns the preliminary exam and gives him 3 weeks to review discovery. But notice something very important about how Judge Simpson frames it. This is not a free delay. It comes with conditions and accountability. The judge basically says, if jail staffing becomes an issue again, don't show up unprepared. Have deputies contact my office and we can adjust. That's smart because it prevents the court from wasting time. Judges hate repeat "I'm not ready" moments. But the judge also recognizes that jail restrictions can sabotage preparation. This section also quietly establishes that the court is trying to protect the defendant's rights even if the defendant is difficult. That's the role of a judge. Not to like you, not to hate you, just to keep the process lawful. And from a storytelling perspective, this is a great transition point in your video, because now the audience knows the timeline, knows the case is escalating, and knows the next hearing is going to be explosive, especially with new felony charges looming.
(2024) at 1, I'm going to set it at 1 p.m. We'll just push everything else out of the way, and that way we'll be here. So that'll give you 3 weeks to try to get through that. Now, if there are issues like what you're talking about, short staff, whatever, and you haven't been able to get through everything, talk to one of the deputies so that they can get in contact with my office, so that if we have to push it out another week, we can just get that done without you coming up here telling me you're not ready.
Fair enough.
Okay.
Got a question in regards to, is there any reason why that would be preferred instead of me being able to address what I got going on internally and at a hospital or outside in the world? I guess me being put on bond so I can take care of my illness as well as look at this discovery and handle that. So it'll probably be done in a more timely manner. There's less variables involved.
Your Honor, I'm not available before then anyway, so I'm very happy to come back in 3 weeks once he's had the opportunity to review it in the jail. And yes, as Your Honor is well aware, if this gentleman's ailments were to the level that he needed to be hospitalized, the hospitalize him. Additionally, the jail would notify their chain of command if there were any needs that exceed the jail's current ability to assist him. I've received no communication from the jail to that effect, which tells me it's not happening, meaning that the jail is the appropriate place for him. Also, Your Honor, I will, as the court knows, the defendant is in custody without bond for the defendant's demeanor in this courtroom. At the time that my office charged this case, we requested a $50,000 cash.
Okay, this is where the prosecution unloads the full narrative, and this is exactly why bond hearings are brutal. Because bond isn't just about what happened, it's about what the state claims you're capable of doing again. They argue he's in custody without bond due to courtroom demeanor and public safety risk. Then they drop the scary details. Firearm possession threats toward the sergeant, threat toward the sergeant's dog, domestic violence call origin. And then there's the line that stands out like a flare. He allegedly said he would cook the sergeant. Now, the defendant later tries to argue that he meant cook legally through court. But here's the problem. Context matters. In a heated police encounter, words don't land like a courtroom dictionary. Officers interpret threats based on circumstances. Also, the prosecutor requests $50,000 cash/surety bond. Let's break that down. Cash/surety means the court is demanding real financial assurance. The amount signals that the state views him as high risk. This isn't petty crime money. This is we don't trust release money. Whether the allegations are true or not, this moment frames the stakes. The court is now looking at him as a danger, not a misunderstanding.
Surety bond. This is a person who, while possessing a firearm, threatened to cook the sergeant, which is one of the reasons that I'm planning to remand the information that serious charges against him. Additionally, Your Honor, this case originally came in as a domestic violence call, and Sergeant Haupt took the opportunity to try to protect the community by proceeding after this defendant in a manner to not only protect one individual woman, but to protect our community. And it resulted in this person possessing a firearm and not only threatening the sergeant, but threatening the sergeant's dog as well.
My rebuttal to that is, when I said cook, I made it very clear. Said it meant legally in the courts, which he iterated on his body cam. So according to the body cam video, he is fully aware that I meant legally through the court process. And also, I believe in the police report, he was sitting there for a welfare check with a possible wrong domestic, which led me being pulled over. Me being a single person in my van, not two people, which would be involved in domestic, I imagine. And then once pulled over, pretty sure he knew I wasn't who he was looking for, just based on my parents' description, based on who was looking up in his talent or the lane system or whatever it is they use in the police cruiser. Make sure to iterate that I plan to use the legal system to address any transgressions or trespasses I felt was made against me. And sorry,
Go ahead.
Also, I was the one who stayed on top of these charges. I'm the one who called the court every day, stayed on top of this case, and I'm the one who arranged the court date with Ms. Fink. I was the one who called the courts week after week, and they didn't have my case in, and finally they did. I was very proactive in trying to get this addressed through the court system. Had no intention of running or trying to avoid it at all. And I think my actions would suit such.
In this matter, I'm not going to at this point change your bond, Mr. Stern, and I'll just put it to you this way. I don't know the facts of the case. By design, I don't. So I'm going to I hear the allegations. I hear your response to the allegations, and at some point I'll see the evidence. In terms of what I had previously heard in regard to this case, I would consider your actions on that date, at least as I understand them to be at this time, that you pose a significant risk.
This is one of the most important judicial explanations in the entire transcript, because Judge Simpson basically tells the defendant the truth that most people don't want to hear. Your behavior affects your freedom. The judge says he doesn't know the facts by design, meaning he's not deciding guilt. But bond is not about guilt. Bond is about flight risk danger to the public likelihood of compliance. And the judge openly acknowledges two factors driving the denial: the allegations, public safety risk, the defendant's prior courtroom behavior. And when the judge says, today was 180 degrees from before, that's a subtle compliment. He's saying, today you were civil, before you were not. That matters. Here's what's fascinating. The judge leaves the door open for reconsideration on August 6th. And that's not weakness. It's judicial professionalism. He gives him a path forward. Stay calm, review discovery, come prepared, show the court you can comply. This is how courts operate. They reward stability. If you want retention, this is a perfect set up what's coming next moment. Because now the audience wants to see, can this guy maintain composure or will he explode again?
To the public and to public safety by your conduct that day. Okay, I'm not sure about the comments. We'll deal with that. Further, as the prosecutor indicated, your demeanor in the courtroom prior to today leads the court to question whether or not releasing you, I could trust you to do what I ask you to do. This is the first time today as we were talking to each other going through the things, that it's been a civil conversation with you to try to resolve the things. All I'm trying to do is get the case through. I don't know why the other days you made a determination to try to act a particular way to the court, because I'm just, like I said, I'm just here trying to get the case heard and get everything done. And so I have, based upon what I hear regarding the case, what I also have seen in terms of your demeanor in the courtroom, I have great reluctance in terms of doing that. What I will tell you is this, is that I certainly will address, so I'm going to deny your request to the extent it was a request to change your bond in this case at this time. Certainly, hopefully we'll be able to go forth on the 6th, and I certainly will relook at everything on the 6th, and you could raise the issue again. But I want you to understand that part of it is because of what the allegations here are. And I'm not saying you're guilty of them. I'm not saying any of that. But in terms of the allegations and what could be and is, from this court's perspective, a situation where you may pose a risk to the community, but also a lot of it is of your own doing in terms of what happened here. Okay. And so all of that I have to take into and can take into consideration. But like I said, in fairness to you on the 6th, because today was 180 degrees from before. And so I will now factor that in. And on the 6th, certainly I will take a look at anything you just raised again before the court. Okay. And I would agree, just real quick, and I'll let you. I would agree with what Ms. Hughes has said, and that is that if your medical, or to an extent, our jail is excellent. I have to say the sheriff's office is extraordinary in making sure that people get the medical care that they need. But certainly you would have to apprise them of that, and I think maybe you have, and they will make sure that you're taken care of. I just don't have a doubt in my mind and have never had an issue with an inmate getting the care that they need. So, all right.
Two things. 4 times we've been adjourned because I asked to represent myself. I don't believe my demeanor played any roles in that. I thought it was because there was some misunderstanding as far as the courts and trying to represent myself.
Oh no.
And in regards to the medical thing, I reported this in May. It took until I got a flood in July before anything was ever followed up on or done.
Okay. I suggest that you send another request regarding the medical issue. And Mr. Styron, I would also suggest to you, it never is an issue. I've had 2 others come through representing themselves. That is never an issue with me, because you have a right to do that. And I'm just going to let you know, that is not the reason. You need to go back and you need to look at what you were doing in this courtroom toward this court for reasons I don't even, Mr. Styron, understand. So I'm not here to debate that with you. I'm just telling you that's where it was.
I wasn't implying that, Your Honor. What I was saying was, maybe I was misunderstood. That when we went to proceed with the court proceedings, there was some misunderstanding in regards to the public defender's office representing me versus me representing myself. Since there was that misunderstanding, it was adjourned, I believe, 4 times over those matters. It wasn't because I was acted out or I believe I came and went so fast. It wasn't even an opportunity.
No, there were a couple of adjournments because of that. Okay. But that was because you needed, there was assistance you needed in regard to what we were dealing with at a particular given moment. And so that's where the PD was standing in. But no, it was your behavior on the date that I revoked your bond. And then the other dates, we're trying to make sure of that. And I was, I'll just be honest with you, Mr. Tyron, I wanted to make sure that you truly wanted to represent yourself and that your rights were protected with having the PD here. And until I was clear on that, I wasn't going to let things proceed because, well, I'll just put it to you bluntly, you got a hot head sometimes. And I wanted to make sure you weren't making that decision just because and not fully understanding what this was, because these are serious charges and potentially more that are coming. That's my whole thing on that. Okay.
I appreciate it.
All right.
One last question, if we're about to be done. In order to get a hold of your office, I can use the channel of the jail, not the mail system, because I don't have envelopes to pass information or anything that the jail is my channel that I go through to contact you and inform you of certain things, be it whether it's documents or
I'm not, well,
or in regards to me needing more time.
I think you would
perhaps.
have to send some type of communication, written communication to my office. I don't think there's a direct line, and I'm not even sure how that works because I usually don't have inmates contacting my chambers directly. Sometimes they will mail things, which seems to me to not be it. Do you? Oh, there he is. So he'll figure that out. He'll let you know how to get a communication up to my office.
Right.
Okay.
Yeah.
And not whether or not I can do anything about it, I don't know. So when that happens, so that you understand this, Darren, whatever you send to me that I'm going to review needs to also go to the other side. But what I will do to try to make things easier, if this is okay with the people, is that once it comes to me, I will make sure that whatever you're sending to me, they're going to get a copy.
That works, thank you.
All right, because envelopes are $1 and I have no money in my account, so it'd be very burdensome to try and buy envelopes to send, to everybody.
They're $1? Seriously?
Tough down there.
I got about $500 in back. That. Okay.
So
What? No, I'm just saying, if I can sell it for $1, I'll just take the whole box down. Anyway, okay, so we sorted that out. Make sure to get with them. They'll make sure it gets up to us.
perfect. Thank you.
Okay,
Yeah.
Mr. Syra, I appreciate you behaving yourself this way. Because just listen, because you're coming in hot like you did before, I'm just going to let you know, with me or any other judge, that's a battle you're going to lose every time.
I can appreciate that, and my only response to that is I've never had that happen. I mean, all the other judges I've ever had on front of, whether traffic or Miss Fink, Miss Fink that was able to have a conversation after the court time.
She's nicer. She's nicer than I am.
She's a very nice woman, that's for sure. And she was able to,
She's much nicer than I am.
like I
And
say,
so
they-
she has patience. Sometimes I don't.
fair enough.
So you got to take it as it is. All right.
Well, have a good
Thank
day.
you. You do the same.
Thank you.
So let's professionally wrap this up, because this case is a textbook example of how courtroom conduct can shape outcomes just as much as evidence does. In People versus Thomas Styron, we see a defendant facing multiple charges, including fleeing a police officer, felony, assaulting/resisting/obstructing, felony, driving while license suspended, misdemeanor. And critically, the prosecution signals even more serious charges may be added, including felonious assault and felony firearm, which can carry mandatory prison time. The court schedules the preliminary examination for August 6, 2024, giving the defendant time to review discovery, especially body camera footage, which is key to building a defense or challenging probable cause. Judge Simpson denies bond at this time, citing two major concerns: the allegations related to public safety and the defendant's earlier courtroom behavior. However, the judge also recognizes that the defendant was significantly more composed during this hearing and leaves open the possibility of reevaluating later.